Judgment in the matter of Lehman Brothers Holdings Scottish LP3 and Lehman Brothers Holdings PLC in administration and others. Case numbers A3 2020 1787, A3 2020 1810, and A3 2020 1811.
For the reasons contained in the written judgments which I now hand down, we have decided that the LBHI2 appeal against paragraph 1 of the order of Mr Justice Marcus Smith be dismissed. The PLC appeals against paragraphs 6 and 7 of those orders be allowed. Paragraph 6 of the orders is varied to read as follows, quote, the liability of PLC under the PLC subdebt has been reduced, including for the purposes of proof, by the amount of any payments made by LBH1 as surety for PLC's liabilities in respect of such claims, unquote. Paragraph 7 of the order is varied to read, quote, the claims of LBGP No. 1 Limited as general partner of Lehman Brothers UK Capital Funding and others under fixed rate subordinated notes rank for distribution in priority to the claims of LBH1 under the PLC subdebt. So far as costs are concerned, SLP will pay the costs of the joint administrators of LBHI2 in respect of the LBHI2 appeal and the PLC appeals to be determined by detailed assessment on the standard basis if not agreed. Without prejudice to that order, the joint administrators of LBH12's costs of both appeals be payable as an expense of the administration. SLP shall pay the costs of the joint administrators of PLC in respect of the LBH12 appeal to be determined by detailed assessment on the standard basis if not agreed. Without prejudice to that order, the joint administrators of PLC's costs be payable as an expense of PLC's administration. LBH1 shall pay the costs of the joint administrators of PLC in respect of the PLC appeals to be determined by detailed assessment on the standard basis if not agreed. LBH1 shall pay GP1's costs of the PLC appeals to be determined by detailed assessment on the standard basis if not agreed. LBH1 shall pay Deutsche's costs of the PLC appeals, such costs to be determined as being 50% of Deutsche Bank's overall costs in both appeals and subject to detailed assessment on the standard basis if not agreed, and permission to appeal to the Supreme Court is refused.
Appeal in the matter of Langer and McKeown and another.
Yes, Mr Carpenter.
May it please your lordships, I appear together with Mr Myers on behalf of the appellant in this matter, my learned friend Miss Lintner, against the respondent.
Yes.
My lord,
I can tell you that we've read the judgment and the skeleton arguments.
I'm very grateful, my lord. As your lordships will have appreciated, this appeal raises a short but important point of principle not previously considered by this court, namely whether the approach to the costs of a trial of preliminary issues where a global call-to-bank offer of settlement has been made should be the same as the approach which is taken where a global Part 36 offer has been made. And as I will make good, where a Part 36 offer has been made, it is clear that, absent exceptional circumstances, the costs must be reserved. In this case, the learned deputy judge...
Well, I think we appreciate that is the effect of Part 36.
Indeed so, my lord. Well,
so
we'll see
the question, as you say, is does the same approach apply to without prejudice, same as the cost offer?
Indeed. Well, what I propose to do, my lord, by way of structure of my submissions is make good what I say should be the correct approach by reference to the key authorities, and then take your lordships to the judgment below to make my submissions on where I say the deputy judge went wrong, and then finally address what I submit this court should do on the assumption that it sets the judge's order aside.
I'm sure we're jumping forward. Can you just tell us whether you say there is a discretion or whether it's an absolute rule that, by analogy with Part 36, a call-to-bank offer should be treated as having a mandatory effect? Is it discretion or principle?
In my submission, the Part 36 approach is really effectively to deny any discretion. It's either an exceptional case or it's not. And if it's not, there is in reality no discretion. In theory, it's a discretion under the rules, but in reality, it's such a constrained discretion that one could call it an absolute rule. And I would submit that to the extent that that is the approach under Part 36, it should also be the approach to a call-to-bank offer.
If you were wrong on that, would you challenge the exercise on the facts of the judge's discretion? Or does your case turn on whether it's a point of principle or not?
It turns on it being a point of principle. That's the basis on which we were granted permission to appeal, and that's the sole basis on which we attack the order that was made.
Understood, thank you.
If I can turn to the law, I appreciate, my lords, that it may be that I can take quite a lot of this relatively quickly, and perhaps by reference to my skeleton argument, rather than necessarily going to the authorities themselves. Certainly much of what I say about the approach under Part 36 ought to be uncontroversial, but there are helpful passages in the authorities that I would nevertheless like to take your lordships to, because I say that they illuminate what the approach should be to a call-to-bank offer. I take as my starting point an acceptance, of course, that the general rule that costs follow the event is equally applicable at the end of a trial of preliminary issues or a trial of liability as it is in any other situation. But I do say that on the authorities, there, as a matter of general application, before we even consider offers specifically, there is a general governing principle which has two elements to it. Firstly, that the costs order should not be dictated by the happenstance of case management. In other words, that there are two trials rather than one. And secondly, that where the result of the second phase may affect the incidence of the costs of the first phase, justice may require that the costs of the first phase be reserved. And I take that principle from paragraph 33 of Mr. Justice Lightman's judgment in Vile and Mean Fiddler Holdings, and I set out that paragraph at paragraph 4 of my skeleton argument. And your lordships will doubtless have appreciated that that was a case which had nothing to do with offers. That was simply a breach of contract claim, where at the first stage it was established that there was a contract, and the costs were reserved on the basis of the defendant's contention that there might in due course be a nil award of damages, and then that could be relevant to where the costs of the liability phase should lie. And that exercise of discretion was upheld on appeal. And we see in the citation, which I won't read out, the 2 points that I have made being discussed. And whilst, of course, not establishing a new principle, I do say, as I set out in paragraph 5 of my skeleton argument, that the way Mr. Justice Norris then approached the question in a case called Biber and Tether and Greenwood is an instructive one.
But if you look at the Mean Fiddler case, Mr. Justice Lightman at paragraph 31 is saying that in any ordinary case, in the absence of special circumstances, the court would be likely to make an order of costs in favour of the claimant who has succeeded on the issue of liability. So that's the starting point.
Yes.
And then he goes on, paragraph 32, is to ask himself whether the judge was entitled to conclude. So that's an exercise of discretion.
That was, my lord.
And he said, well, yes, he was entitled to conclude. But the fact that Judge A is entitled to conclude one thing doesn't mean that Judge B isn't entitled to conclude something else.
Well, as it stands, Vile is, of course, no more than the upholding of an exercise of discretion that was within the bounds of reasonable discretion. But there are nevertheless, in my submission, statements of principle that have been taken, regularly taken in subsequent cases, to be statements of principle. In my submission, that's how they should be approached. Of course, at the Vile level, if I can call it that, we are encompassing, as I say, not specifically offers, but anything that anyone can think of, potentially, that might affect the incidence of costs later. So in Vile, it was, well, there might be a nil award of damages. Now, in practice, actually, that sort of submission doesn't seem to get terribly much traction. But clearly, Mr. Justice Lightman was not concerned with offers.
I think strictly you mean an award of nominal damages for each contract.
Yes, I'm sorry, my lord. You're right. Correct my terminology.
40 shillings it used to be.
Nominal damages, or indeed a worthless order for specific performance. So,
But as you accept, I think, that even in a case where the outcome after liability, maybe you get nominal damages. A trial judge is perfectly entitled to say, well, you've fought liability uphill and down, you've lost, I'm going to make you pay the cost of it.
And it would all depend on the facts of the case, but in principle, of course.
And even if you make a Part 36 offer, Part 36 only entitles the defendant to costs as from 21 days after the date of the offer. So even if the claimant fails to beat the Part 36 offer, the claimant will still be entitled to her costs up to 21 days after the date of the offer if the court rules on the issues in her favour. Now, the judge in this case had no idea when the without prejudice offer was made, nor do we.
Well, my lord, we do, and in fact it is the respondent's fallback submission that is an order which this court can and potentially should make. The date of the offer, I can tell your lordship, was the 27th of May 2020. And indeed, last night, and I'll come on to this when it's material to do so, we were given by the respondent's solicitors details of what they say the respondent's costs up to 21 days after that date.
But the point is that the judge who was being asked to exercise his discretion didn't know.
No, he could certainly have been told.
Well,
but
it sounded as though, from what Mr Tager was saying to him, as though Mr Tager didn't want to say anything at all about the without prejudice offer.
Well, my lord, I think in fairness to Mr Tager, it wasn't suggested by either side that the judge could know the date of the offer. And of course, the submissions were very stark on both sides. The submissions for the petitioner were that she should have her costs up to that point,
yes,
the holding proceedings up to that point, and for my client that the cost should be generally reserved. Now, the judge was with the petitioner on that, so the alternative possibilities never arose. I absolutely
wouldn't that have been for your client to put forward that possibility? Judge, even if you're against me on the submission that the existence of a without prejudice offer paralyses the court's discretion, nevertheless your discretion is only limited to the 27th of May 2020, something like that.
Well, my lord, I'd respond to that in two ways, if I may. If it goes to my client's ability to argue this appeal, or what this court might do in the event that the order below is set aside, then in my submission it doesn't. My client argued for an outcome which the judge didn't accept, and if he made his order for unprincipled reasons, then the order has to be set aside, and this court can must re-exercise, subject to the possibility of the matter being remitted, the discretion. And certainly I accept at that point, it's open to this court to exercise the discretion in any way that it sees fit. As to the principle, and I'll deal with this in more detail later if I may, while of course it may well be the case that in a case where a Part 36 offer or a call-to-bank offer has been made, the offeree will get their costs up to the end of the relevant period. We do not actually see that happening in the authorities. We have in the authorities bundle 2 cases where that was contemplated by the court, and in both cases the court decided not to do so, for what I will say in due course are very good reasons.
Right.
My lord, in terms of the principles, perhaps I can pick this up with the HSS case in this court, which is probably the most significant case because it establishes the principle that applies where a Part 36 offer has been made. And there are a number of aspects which informed the approach taken by Lord Justice Waller in that case, which I submit are equally applicable to a call-to-bank offer. And your lordships will find that behind tab 8 in the authorities bundle. This was a case where the defendants had been held liable following a trial on liability. The defendants had made a Part 36 payment into court, and the judge below had nevertheless ordered the defendants to pay the costs of the liability trial, and this court allowed the defendants' appeal. There was also a substantive appeal, so we can pick this aspect of it up at page 74 of the bundle. And we see the question posed in the last 3 lines of paragraph 26, where there's an orange marginal mark. In paragraph 27, we see references to submissions made on behalf of the claimants, which are relevant given some of the points which are taken against my client on this appeal. So we see it being said that Mr Dunning robustly argued that it was open to them to concede liability, and if they chose not to do so, then liability for costs followed if they lost the issue. And Lord Justice Waller going on then to note, if that approach is right, it seems to discourage the arguing of preliminary points. Then paragraph 29 in my submission contains some important policy considerations. The learned Lord Justice said the contrary approach is that parties should be encouraged to make Part 36 payments in and or offers. They should also be encouraged to try preliminary points if that could lead to the saving of costs overall. If payments in are to be totally ignored at the conclusion of the trial of a preliminary issue, that will discourage applying for the trial of the same and may even discourage Part 36 offers where preliminary issues have been ordered. The proper approach at the conclusion of a trial of a preliminary issue where there has been a Part 36 payment in or a Part 36 offer should therefore normally be to adjourn the question of costs pending the resolution of all the issues, including damages, at which stage the quantum of the Part 36 offer can be revealed and the discretion in relation to costs exercised in the knowledge of it. We then see in paragraph 30, and I pick this up because again it's relevant to some of the submissions that my learned friend will make, various points which have been made on behalf of the claimants that I particularly highlight at the middle of that paragraph, point 4. Again, we see the defendants could have admitted liability but chose to fight it. And then we also see a little further into that paragraph reference to quite serious conduct points. Mr Harrison was described as disingenuous and Mr Sosin as totally unreliable, and reference was made to Rule 44.34, under which it was material to take into account the conduct of the parties.
What Lord Justice Waller says at paragraph 29 seems right, doesn't it? That if the existence of a without prejudice offer paralyses the court at stage 1 of the trial, then it will discourage people from asking for trials of preliminary issues. So the courts will get clogged up with dealing with issues that may never need to be resolved.
Well, my Lord, with respect, I think the learned Lord Justice was making the opposite point, that if the claimants in that case were right, if the payment in was to be ignored, that would discourage the trial of preliminary issues. It's certainly a point that I will be praying in aid on the question of call-the-bank offers when I compare the two.
Can I just ask you this? Underlying paragraph 29, and I think probably paragraph 35 as well, is an assumption that it's a good thing to have split issues. In an appropriate case, then you don't want costs to unnecessarily deter the formulation of preliminary issues. Is that fair?
Yes, that is one policy consideration, and the other is generally encouraging the making of offers in whatever form.
Absolutely. Now, can I hypothesize a situation? Assume you have a derisory Calderbank offer, which the respondent to the petition knows will never ever be accepted. If you're right, doesn't that deter the formulation of preliminary issues? Because it means that the petitioner will never get costs on your analysis. Which I suspect is what Mr Lindner is going to suggest sub silentio about the offer that was made.
Yes, I mean, I should be clear about that, and I'm sure my learned friend would agree with this proposition. No implication as to the terms of the offer that we are concerned with here should be read into any of her submissions. And of course, I don't need to tell your lordships that we must not speculate in any way what the terms of the offer
That's why I put it as a hypothesis.
But if I'm to address the principle, of course, I have to address the possibility that there may be those facts. Now, what I call the defeatist response might be, well, yes, if you're going to have that principle in the interest of justice, that is a risk that you run. And there's absolutely no doubt that you run that risk in relation to a Part 36 offer. The point about a Part 36 offer that my learned friend seizes on in her submissions is, well, it carries with it an entitlement to costs. But beyond that, you can pitch the offer wherever you like. And it's quite clear that the court is not going to inquire, cannot inquire, at that preliminary stage as to whether the offer is tactical or derisory. And in fact, we see this point addressed in one of the cases, and perhaps I can take your lordships to that. It's the original beauty case at tab 19 of the authorities bundle.
But even if a Part 36 offer has that deterrent effect, is that a reason to extend it as a matter of policy to Calder Bank Office?
Well, of course, the risk is always of throwing the baby out with the bathwater. One can often conceive of extreme circumstances which might test a principle, but in the majority of cases, the principle is going to remain. And an important aspect of my submissions, which I'll make now, is that all reservation of costs does is hold the ring. There is an undercurrent of presumption in Milena Friend's submissions that there is something inherently unfair about that because it is denying the petitioner the cost to which he's otherwise entitled. But that very obviously begs the question. There can be no assumption at that stage about who ultimately in justice should have those costs.
Well, it's largely about cash flow, as much as anything else. Particularly if you've got a minority shareholder who's trying to bring an unfair prejudice petition.
That may be right, and Milena Friend's arguments place a lot of weight on what is said to be the petitioner's impecuniosity. Can I just, as a matter of fact, update your lordships on that? It's a submission which should largely fall away because the interim payment of £200,000 that was ordered and about the non-payment of which complaint is made has been paid along with the cost of that application and the full amount of Judgments Act interest. That was about a month ago. So the petitioner should now have a fighting fund to enable her to proceed to the quantum stage. But if I can
just before you move off this point, do you accept as a general principle that it's a good thing if people who fight bits of litigation and lose should not only pay the costs at the end of the day, but should pay the costs there and then? That's something the CPR encourages.
Well, what I would submit, my lord, is a good thing is if the ultimate disposition of costs is fair in light of all of the circumstances. And there may be many cases in which that is the fair result. But if an offer has been made and the court cannot speculate as to how generous or not it has been, it may very well not be fair. And if the court has the choice of doing a permanent injustice there and then, or risking a permanent injustice there and then, or simply putting off the day at which that determination is made, with all options kept open, in my submission, the latter it must be the infinitely preferable choice.
And that would apply, would it, to all interim applications? In any case where a Part 36 offer is made? So if you resist an order for, I don't know, specific disclosure or something unsuccessfully, you don't pay?
No, my lord, and I don't think I've ever encountered such an argument. I don't think one sees it in the authorities, but there's a principled reason for that, if I may submit as much. Interim applications are not part of the mainstream of the litigation. They are not an aspect of trying the case. They necessarily stand outside it. They are self-contained. And there are two consequences of that relevantly to what one might call the vial approach. The first is that the ultimate result of the case is not going to shed any light on who ought to pay the cost of that interim application. And secondly, we're not in the realms of happenstance of case management. The interim application is always going to be heard separately. And so the costs are always going to be dealt with separately. And of course, my lord, if it's a good point, it's a good point equally in relation to Part 36 and Calder Bank. A theme of my submissions will be that many of the points which are taken against my argument are points which apply equally to Part 36. So one, in my submission, that the appeal cannot be dismissed without drawing distinctions between Calder Bank offers and Part 36 offers, which don't in fact rest on principle.
I should know this, but when a Part 36 offer has been made, what's the impact of that upon interim applications under the CPR?
None under the rules, and I think it's also an important point to make that none of what I'm arguing for arises under the rules. One doesn't find the approach in HSS set out anywhere in Part 36. This has nothing to do with the mechanisms of Part 36. All one finds in Part 36 is rules about disclosure of offers, but the mechanism for dealing with them is predicated upon the fact that they can't be disclosed, just as a Calderbank offer can't be disclosed, but is otherwise judge-made law.
One of the problems with Part 36 is the rules keep changing. And it is a very prescriptive code, and one needs to look at each iteration of the code. But am I right in thinking that under the current code, it's not confined to monetary offers? It was originally a substitute for payment in, and it was payment in with consequences.
One can make almost any kind of offer under Part 36 these days, but not quite any, and it is still restrictive. It's particularly restrictive in relation to the cost consequences, for example. I mean, a very obvious example of problems with Part 36, which may lead parties to make offers outside it, is where you have a claim and a counterclaim. If you want to make a net offer on a claim and counterclaim, you have to agree, if it's accepted, to pay the claimant's cost of the entire proceedings. And one can think of very many circumstances in which that is an extremely unattractive proposition.
Up to the date of the Part 36 offer.
If accepted, so that will be the entirety of the proceedings.
Yes, I see.
Another area where there isn't flexibility in Part 36 is in relation to interest. This court decided in a case called King and the Corporation of London at the end of 2019, and it's now embodied in the rules, that you can't make a Part 36 offer which excludes interest. Now, there may be a case in which that is a sensible offer to want to make. But beyond that, and again, this deals with a thread that runs through Malone Friend's argument, we don't have a hierarchy of offers under the rules. We don't put Part 36 offers up here and say these are the best kinds of offers, and Calderbank offers are a lesser form of offer which you shouldn't make unless you absolutely have to. If you want the benefits of Part 36, you have to make a Part 36 offer, and they may be good or bad for you in the particular case. But the rules mandate the taking into account of offers made outside Part 36, and we see very many examples in the authorities of a defendant's Calderbank offer in practice having the same effect as a Part 36 offer.
I thought there was a principle that if it was just a money claim and you could pay money into court, you were meant to use that, and offering money outside what's now the Part 36 regime didn't give you much cost protection because you weren't supposed to do it that way. Am I wrong about that?
Well, my lord, there was a case, I think the key case is Stokes, and if I have the opportunity later I can find where it's dealt with in the White Book. But the point is, once you're outside Part 36, it's a question of discretion. But if you make a Calderbank offer, which is to all intents and purposes as good as a Part 36 offer, you offer to pay the claimant's costs, you keep the offer open for 21 days, let us say, and the offer was a generous one which the claimant obviously reasonably should have accepted, you have a very good chance as a defendant of being awarded your costs, or some of your costs. It doesn't have to be all of them. The point is, it will feature in the exercise of discretion. The rules mandate that it features in the exercise of discretion.
But you made an assumption there that the offer was very good, should have been accepted, something which the judge is simply oblivious to after the preliminary issue. And there's a lot of evidential and factual assumptions which you're then using to turn into a general rule. We have to take account of the fact, the point you made earlier, that the Calderbank offer may be derisory, it may be very good, it could be something in between.
Well, quite, my lord. In using that perhaps slightly overblown language, I shouldn't be taken to be sort of setting myself a test. I'm simply giving an example of circumstances in which it's very foreseeable that a Calderbank offer would lead to the same cost result as a Part 36 offer. But again, a theme of my submissions is one doesn't know, one cannot speculate. And that is precisely why these matters have to be left until later. Can I just, before we leave the question of derisory offer, show your lordships what was said about this in the original Beauty case?
Yes.
At page 203, tab 19 of the authorities bundle. And the judge there dealt with very much the same submission at Little Roman 3 on that page. Given the length of that paragraph, it might be easy if I simply invite your lordships to read that, because the point is dealt with there.
This was a case about a Part 36 offer,
Yes, this was a Part 36 offer.
and it entitled the judge on the basis of this paragraph to determine that the offer was genuine and not derisory.
Well, he wasn't making a determination, my lord. He wasn't in a position to do so. He was addressing a submission that it might be. I mean, no one could have told him whether the offer was genuine or derisory, but the concern was expressed that it might be.
Is there a requirement of Part 36 that the offer be, quote, genuine, unquote?
Well, this comes in, my lord, to the question of whether in due course it would be unjust to visit the automatic consequences. It's one of the specific factors that are listed in 3617. I think it's 5. We do actually have, if your lordship wants to see it, we do actually have the relevant parts of Part 36 in the authorities bundle.
It has to be a genuine attempt to settle.
Yes, and there have been cases about if you're a claimant and you offer to take 95% of damages, that's a genuine offer, that sort of thing. So it's,
yeah.
When Part 36 first came in, it was recommended to claimants to offer to accept all but a penny of their claim. And then if they won, they got the extra uplift on costs.
yes, I believe so, my lord. And as your lordship says, of course, Part 36 is ever changing, in part responsive to attempts on both sides to game the system and discoveries of loopholes which people didn't previously appreciate existed. But the key point really is, and I do apologise for repeating this, and I'll try not to do it too much, is that reservation of the cost simply holds the ring. It allows the court in due course to act at a time when it can know everything. And the court's powers then to do justice are very wide. For example, the court could backdate Judgments Act interest to the date when it considers that the cost order should have been made. And it might do that in a case where, in fact, it turns out that a Part 36 offer was purely tactical or derisory.
Yeah, I'm having a bit of difficulty with this. Part 36:17 deals with what happens when the claimant fails, is it, to beat the Part 36 offer?
Well, it's both ways, my lord.
Both ways.
So in 3, we have the situation where the claimant fails to beat
Right.
a defendant's offer. And then in 4, we have the situation where a claimant does at least as well as its own offer. And then 5 is a list of common considerations in both circumstances when deciding whether it's unjust to make what would otherwise be the usual order.
But if the claimant fails to beat the defendant's Part 36 offer, how could the court say that it wasn't a genuine attempt to settle if in fact the claimant's done worse?
I think the answer, my lord, is that that is unlikely to arise in those circumstances. The arguments tend to be where claimants have offered a nugatory discount on their own claim in the hope of getting the uplift and so forth that follows from beating their own offer. But yes, if a defendant offers 5% of a claim and the claimant gets 1%, the claimant can hardly complain at the consequences. But it is relevant to mention now, when we're considering the concept of injustice, that this is also the answer in many ways to submissions that are made about asymmetry of information. Because again, all of that can be taken into account at that point, and taken into account much more easily than it can at the earlier stage. And I'll say a bit more about that later.
Those policy considerations, no doubt valid, are considerations the judge in the present case could have taken into account. He could have said, well, there's a number of factors, your client's behaviour during the trial, who won on the merits, but also the fact that I need to reserve to the trial judge the ability to see these things in the round. Now, weighing those things up, I've still decided to make a costs order. So nothing precludes the judge exercising discretion, taking that policy consideration into consideration. Is that right?
Well, my lord, the essence of my submission is that absent an exceptional case, which is the expression used in HSS and then picked up by Mr Justice Jackson as he then was in Multiplex, and an exceptional case consistently with the basis on which the normal approach is taken, must be one in which any potential for injustice is eradicated. If the reason for reserving is the risk of injustice, then you can only not reserve if you can be absolutely confident that you are not risking an injustice. And so, as we'll see in multiplex, the way Mr. Justice Jackson approached that was that he was satisfied that the offers that he was concerned with were simply not relevant to the issues that he had been dealing with. So he had no difficulty in holding that he could make an immediate costs order. That is, as far as I'm aware, and doubtless if there were other cases, my learned friend would have found them, I haven't seen them, the only example, in fact, in the case law of an immediate costs order being made in the face of, certainly a Part 36 offer.
You started by saying your submission was absent an exceptional case. You were about to complete the sentence.
Yes.
You then went off on a...
So an exceptional case has to be one in which that injustice can be eradicated. And I submit as a matter of principle the same should apply to a Calderbank offer. So if the deputy judge below had directed himself that he should take into account, for example, the risk of an injustice being done, but nevertheless had gone on to make a costs order, I would be submitting that that was a flawed exercise of his discretion, just as much as if, as happened, in fact, he rejected the principle completely.
So your case does boil down to a conclusion that it's hard to imagine any exceptional circumstances. When a Calderbank offer is made, effectively, the Part 36 bind applies and you defer.
My lord, it does, except in an unusual case like multiplex. So there is, HSS contains the exceptional case safety valve, but one has to be very careful with what an exceptional case is. Exceptional case is not, in my submission, a discretion to identify something about the case which is unusual, be that an aspect of conduct or whatever it might be. And people have tried this and it doesn't work. It has to be a case in which the circumstances are sufficiently exceptional that the offer could never bite later.
Can I ask you something else, which is not really featured in either side's submissions, which is, as my lord said earlier, that the concern is one of cash flow. And you've made the point that you're not saying the petitioner should not have the costs, you're saying the question should be put off until full information is available, because it's just a question of timing.
Yes.
Could a judge properly say, well, I think the petitioner has won this stage of the litigation and should have their costs now. That is subject to a trial judge, once they've seen the full information, reversing that order and ordering repayment of costs. But as matters stand, I think the petitioner should be put in funds which she's had to expend to fight this far. Could a judge properly do that?
Well, in my submission, no, my lord. Of course, one doesn't see it in the authorities, but that doesn't mean it's not possible. The answer is that impecuniosity is simply not a relevant consideration in deciding what costs order to make. It can come into later questions of, for example, the amount of a payment on account once you've made a costs order. But impecuniosity does and should not drive the incidence of costs. And we have one example in the authorities bundle of that point being made in passing, the references in my skeleton, that cost orders on principle do not depend on the party's financial positions. It's not the purpose of a costs order to give one party at the expense of another a fighting fund for the next stage of the proceedings. And of course, the risk of injustice is just as great in any event, because if that party is impecunious and if they're going to spend everything that they're going to get fighting the next stage and the other party gets their costs in the end,
They might not get it back.
the result is just as bad. My lords, may I just to finish off with HSS come back to paragraphs 35 and 36 at page 76 of the authorities bundle.
Page 76, did you say?
Yes, tab 8, page
Yep.
76. And we see here, and I won't read it all out, we see here the expression of principle. Three important points that I take in particular from the end of paragraph 36. Firstly, in fact, I think, no, the reference to perhaps the most exceptional case, I think, actually appears in paragraph 35. But anyway, where it is in paragraph 35. There's no gloss, of course, on that. It's an expression which is, I would say with respect, the kind of safety valve which any court is going to incorporate into a principle, because it's not relevant to the case before it, but it doesn't want to shut out the possibility, however inconceivable it may be, that there may be an extreme case where something different should be done. But it is expressed in very limited terms, perhaps the most exceptional case. Secondly, an important point considering how the learned deputy judge in this case made his decision is that Lord Justice Waller considered that this was an approach which was mandated by what was then CPR 44.3 sub 4 that we see at the top of the page, actually quoted in paragraph 32. Because what the rule required then, it's been slightly reworded now, but the principle is the same, is that the court must have regard to, when making costs orders, inter alia undersea offers, whether or not in accordance with Part 36. What's actually different about the current iteration of the rules, we'll see, is it no longer refers to Part 36 offers, but it says the court must have regard to other, without prejudice save as to costs, offers. And the point made by Lord Justice Waller is that if the court knows there's been an offer, but makes an order that doesn't take it into account, then it is effectively in breach of that rule, because it has determined costs to which that offer would be relevant, but it's done so without regard to the offer. And that's what the learned Lord Justice means when he says at the end of paragraph 36, in any event, because the court was not allowed to know the quantum, it could not act as required under Rule 44.34 at that stage.
If this were a public law case, I would say that you were saying that the judge must address herself or himself to the question of offers. If the judge addresses that matter, you can't say that they've ignored a relevant consideration. If the judge says, however, all I know is that an offer was made and I know nothing more about it at all, so I therefore really don't know how to weigh it in the scales, I've got nothing to grapple with, are you saying that's an error, to exclude it, even though the judge has addressed it?
My lord, I would, because the addressing...
So the judge addresses it. If the judge has zero knowledge about its probative value, then that then triggers complete deferral.
Well, what my lord calls addressing the offer, I would say with respect, is simply a statement of the factual circumstances which are then pertaining. Namely, there is an offer, and the court cannot be told what it is. What the rule then requires is for the offer to be taken into account. And I would submit it's not taking it into account to say, I acknowledge that it's there, but I'm going to make an order for costs that disregards it.
What the rule precludes is that he mustn't be told the terms of the offer.
Yes.
It doesn't say he mustn't be told when the offer was made, for instance.
No, my lord, no. And that is in the open in this case.
Well, it wasn't before the judge.
No, it wasn't, and we've been over that ground. But no, there's no difficulty with the court knowing when the offer is made. Certainly not. What it can't know is its terms.
No. Can I get back to what Lord Justice Waller is saying at the end of paragraph 36? I think your submission was the then terms of CPR 44.34 required the court to take into account the fact that there had been an offer, because the court must have regard to any payment into court or admissible offer. But I'm not sure that's what Lord Justice Waller was saying. I think what he's saying in the last sentence of paragraph 36 is the court can't take into account the offer because it doesn't know the quantum. Hence it should be deferred, which is a different point.
Yes, my lord. It may be a question of how it's expressed, and I'm sure your lordship has put it better than I did. But the point is that at the time when those costs are to be crystallised, if I can put it like that, all relevant offers must be taken into account by the court. And if the court crystallises those costs, knowing that there is an offer out there that could be relevant but it can't then see, it has acted contrary to that rule by then making a once and for all time order in relation to those costs. That's my reading of
The
that.
way the judge approached it was to say, well, I'm not allowed to look at this offer. I know there is one, but I don't even know who made it, let alone when it was, or what its terms are, or anything. I don't know anything about it, other than the fact there is one. That's not an admissible offer within the meaning of the rule.
It's not admissible, no. And that was in large part the deputy judge's justification for not having regard to the offer. But
Well, was he wrong to say it's not admissible?
the terms of the offer were not admissible. The fact of the offer was admissible. If it had been put before him, I would say it was sufficiently implicit that it was an offer by my client, but certainly the fact that it was an offer by my client would have been admissible, and the date of the offer would have been
I'm not
admissible.
certain you can say that. I mean, paragraph 25, the judge says, I've not been told who has made the offer. So that was a matter which both parties, reluctantly or otherwise, decided not to put in front of the judge. And I don't think it was open to him to speculate as to who might have made the offer.
On those facts, my lord, that is probably right. Had he asked, the parties might or might not have told him. Obviously, that would also be speculation. But the fact of who has made the offer is admissible, and what the offer relates to is admissible. The fact that the offer is an offer which would dispose of the entire proceedings is admissible.
Why is that admissible? When you write a called-about letter, it says at the top, without prejudice, save us to cost. We know that that means, because of a decision called about, that you can't look at it at all during the trial process. You can only look at it at the end of a trial process when it comes to deciding the costs. So why can you tell the judge, without the consent of both parties, that it relates to the entire claim? It might relate to something, relate to one discrete bit of the claim. It might relate only to whether the petitioner's loan account should be written off. I mean, one knows literally nothing about it, and one is not entitled to know anything about it. And it does seem to me you're trying to put the fact of the offer before the court in a way which assists the deferral of the cost decision, but without telling the judge anything about it, but sub silentio inviting the judge to infer that it was really your offer and it was really to dispose of the whole case and that it therefore might have an impact on the costs at the end of the day. But all that is speculation, isn't it?
Well, my lord, I have to say, I hadn't anticipated this line of argument, and it may be that I need to have a look back at the transcript of the hearing to see what was in fact said to the judge about this. We don't have it in the bundle because it doesn't seem material, but certainly we on this side have a full transcript of the hearing.
Well, I think we've got paragraphs 25 and 26 of the judgment, which is the judge's findings of fact about this incident. And he makes it clear that I think it was your client that resisted putting even the redacted correspondence in front of the judge. Now, whether they're right or wrong, it's not really for us. Those are his findings of fact, and they're not challenged.
Yes, my lord. Now, that is actually a factual error by the judge, and it arose in this way. It's not specifically the subject of the ground of appeal, and I submit it doesn't need to be, but it is a confusing aspect of his judgment in my submission. It arises because there were, without prejudice save as to costs, offers made by the petitioner, which the petitioner submitted were admissible at that stage. They were pertinent to stage one. But their admission was objected to on the basis that the correspondence also included material which was relevant to stage two. And the petitioner had proposed to put redacted versions of that correspondence before the court. That was objected to, and in fact, the judge was never asked to rule on it. So he never saw that material, and he was never asked to decide if he should see it. Nobody suggested that the judge should see even a redacted version of the offer that we are concerned with. And so the deputy judge does seem to have been confused about that. The position in relation to the offer that we are concerned with is that it was common ground that he could not see it, and no one was suggesting that he see it.
So, in relation to the petitioner's offer, it did contain something in relation to stage one. We don't know what. But a successful objection was maintained that the judge should see even a redacted version of that offer. And as you say, there was no ruling, it was just the attempt to put a redacted version was not persisted in.
Yes.
In relation to an offer from you, nothing was before the court at all, apart from the fact that there was an offer.
Yes, and that's what one would expect. But if I could come back, because I didn't actually deal with my Lord's question about the admissibility of call the bank offers. Certainly my understanding is that it's always been accepted that the fact of the offer is always admissible. What is inadmissible is its terms. We see in the authorities that the matters that I've referred to are commonly admitted. Now, it may be that that is with the express or tacit consent of both parties. But if the other party takes a hard line, let's say the claimant, in the face of a defendant seeking reservation of the cost by reference to a call-to-bank offer, says, well, I object to you saying anything about this offer at all. It was made without prejudice, save us to costs, and that is a contractual agreement that you cannot even mention the offer. Well, then we are into the territory that Mr. Justice Eder was dealing with in the Ted Baker case, which was a Part 36 case. It may be helpful to look at this. A Part 36 case at a time when the then iteration of the rules did indeed prevent the court from being told at the end of stage one even of the existence of a Part 36 offer. So this is subsequent to HSS. There's been a change in the rules, and that change has effectively been reversed since, But there was a period of time when one couldn't even tell the judge at the end of stage one that there had been an offer. The somewhat highly artificial result that led to was decisions that the judge could be told if there hadn't been an offer, because that is not privileged information, but couldn't be told if there had been. So one might think that the natural assumption would be, if one hadn't been told that there hadn't been an offer, that there was. But one of the points that
Like saying the defendant in a criminal trial is saying nothing about his good character.
Exactly so, my lord. And what Mr. Justice Eder dealt with...
Negative inferences may be drawn in such circumstances.
Well, quite, my lord, and it's perhaps not surprising that rule change was then reversed, because it served no useful purpose. But one of the points that Mr. Justice Eder had to deal with was a submission on behalf of the claimants that he could not take into account the possibility, even, that an offer had been made. And he dealt with that. This is tab 13 of the authorities bundle at page 142. And it's paragraphs 22 and 23, but maybe I can just invite your lordship to read those two paragraphs.
Paragraph 27, he says that he's going to defer costs, but he also recognises that's a matter of discretion. In some other cases, as Mr. Justice Henderson had held, I think, in an earlier case, you could, even taking into account those speculative inferences, make a cost order at the interim liability stage. So it comes down to discretion.
It does, as it's expressed there. I didn't show your lordship's paragraph 37 of HSS, which really does confine, I would say, to the point of elimination, there being a discretion. What was bedeviling decisions at that time, including the decision of Mr. Justice Henderson, who then was, that's referred to here, is this vexed question of, well, what do you do when you can't even be told that there is an offer? Now, those considerations have fallen away, and one sees the thrust of all of the subsequent cases is Part 36, global offer, means automatic reservation of cost.
But just teasing this out, your submission is that even if you can't know about a call-to-bank offer at the end of stage 1, you should adopt the same approach as Mr Justice Eden did with Part 36, he couldn't know about it until Bacon, and assume that it's a possibility that there's a call-to-bank offer which might affect the cost of stage 1, and therefore it should be deferred. But that would lead to you always deferring the costs of split trial, unless the parties were agreed that no offer of a call-to-bank type had been made. And since parties will only agree what it's in their interest to agree, it will always be in the losing party's interest to refuse to agree with it.
Well, my lord, on what we may call the evidential question, there should be no reason why the parties would disagree about the fact that an offer hasn't been made. If one party wants to say no relevant offer has been made, that is either accurate or it is not. And if it is not, one would expect the other party to dispute that. But also, that it would be unattractive in my submission to allow a claimant, let's assume a claimant, who is the offeree of what may be a generous global offer made during the preliminary stage of the proceedings, to effectively stymie that offer having any effect in relation to the liability cost by simply saying to the offeror, no, you can't tell the court anything about this. That is as tactically unattractive as the possibility put to me by Lord Justice Green of derisory or tactical offers being
Well,
made.
I mean,
on
the
offeror's
judge's view at para 30 was that your client can't have it both ways by withholding admission of the evidence and still asking the court to take account of it. So, in response to your hypothetical claimant, a court might say, well, claimant can't have it both ways. So either I do take account of the offer, or I don't. And if I don't,
well, my lord, the difficulty is, in the strict admissibility scenario, the court probably can't even be told that there is an issue as to it. If the defendant wants to put the existence of a call-to-bank offer before the court, and the claimant says, well, the effect of our without prejudice compact is that you can't even mention the offer, then unless another judge is going to be asked to rule on that, and then it comes back to the first judge to make the call, the court isn't in a position to know that one party is acting tactically.
Well, isn't the practical solution that once a split trial has been ordered, people who want to make global offers should put in their call-to-bank offer the possibility of referring to the offer for the purposes of the costs of stage 1 at the end of stage 1. Now that may mean that whoever determines the cost of stage 1 is then not going to be suitable to determine stage 2, but that seems to me to be a practical solution.
Well, my lord, it might be, but the fact that one can fashion perhaps not completely straightforward answer in particular cases doesn't, in my submission, detract from the principle. The principle is that parties during a liability stage, preliminary issue stage of proceedings, a defendant in particular, should be able to protect themselves in relation to the overall result of the case. And the approach for which my learned friend contends, it effectively, certainly outside Part 36, denies the defendant the possibility of doing that. Now, the ability to make a protective offer is one of the most important weapons in a defendant's armoury, within or outside Part 36. The tactical advantage given to a claimant by the approach which my learned friend contends would be enormous, because during the Part 1 stage, you are saying to the defendant, you can either fight liability or you can make a protective offer, but you can't do both. So if you want to make a protective offer, throw in the towel on liability and then we can talk about quantum. But what if the defendant thinks, well, it's a 50-50 case, I don't know, it might go either way. I've got a good shot at liability, but also I want to protect myself on the overall result.
but I think in answer to Lord Justice Nugee, I think you said that you could make a Part 36 offer in whatever form you like. So it could be,
Yes.
could be a sum of money, it could be a formula. So it was open to your client to make a Part 36 offer in this case.
Yes, for let us assume in the same terms as the offer which
Let us assume.
has been made.
Yeah.
Yes.
And he chose not to, for whatever reason.
Yes. Well, my lord, as I said, the way matters operate is that we don't have a hierarchy of offers. If one is trying to rely on a call-the-bank offer, there isn't a condition precedent.
Maybe we do have a hierarchy of offers. Because as you say, Part 36 is utterly prescriptive, and Part 44 simply requires the court to take account of admissible offers.
Yes, to that extent one could say that, my lord, but I've already given a couple of examples of circumstances in which it would be entirely understandable that a non-Part 36 offer has been made. But of course the court can't even ask the question, could you have made a Part 36 offer, without seeing the terms of the offer which was in fact made. And as I say, in my submission, when costs are approached at the end of a case, and we certainly see it in the two examples that we found of judges at High Court level doing exactly what we submit is the right approach and treating call-to-bank offers for these purposes in the same way as Part 36 offers. No question arises as to, well, you could have made a Part 36 offer. The fact that it's not a Part 36 offer is simply a fact. That is something which will ultimately go into the exercise of discretion.
You said there were two cases you had where High Court judges done this. I saw the one of Mr Johnson's Lewison.
Yes.
What was the other?
The other is the Tullett-Prebon case, a decision of Mr Justice Jack. And we see that at tab 10 in the authorities bundle.
Was that not a Part 36 case?
No, my lord, this is a call-to-bank case.
In which case the head note misleading.
I hadn't actually... my lord is, of course, absolutely right. I hadn't actually read the head note. But we see in paragraph 3, two call-to-bank letters. And
Thank you.
In paragraph 7, we see the learned judge's conclusion, page 94. I'm satisfied that it would be plainly wrong to make any order in respect of costs incurred after the 19th of October 2009. And in fact, it seems that counsel had not really pressed the submission. He certainly needed no persuading. Having set out just above the cases that I refer to, that the right approach was also to do the same in relation to a call-to-bank offer.
And so the 19th of October 2009, which he refers to in para 7, that's the 21 days after the first of the call-to-bank offers.
It is, my lord, yes. And in my submission, it does...
And he's told the dates of the two offers.
Yes, one sees the dates, yes. It does come down, in my submission, my lords, to the stark proposition, really, that the only principal basis on which one can make a distinction is if this court is to say, if you can make a Part 36 offer, you must make a Part 36 offer. But then we run into precisely the difficulty I articulated a moment ago, which is how can you know if you could have made a Part 36 offer until you see the terms of the offer, which was in fact made. I think, my lords, in the course of our exchanges, I have effectively made my submissions on how I say the principles should apply. What I will do then briefly is deal with some of the points which are made against me.
Yeah.
And by reference to paragraphs 40 onwards of my learned friend's skeleton argument,
Yes.
Paragraphs 40 and 41 effectively complain that what we are seeking to do is have the benefits of Part 36 without complying with Part 36. And that is, in my submission, a mischaracterization of the argument. As I've said, the principles that govern the treatment of Part 36 offers in this situation don't come from the rules, but they come from broader considerations of justice and policy. So I'm not in any way asking for our offer to be treated as a Part 36 offer. All I'm saying is that the considerations of justice and policy which guide the treatment of Part 36 offers should also guide the treatment of call-to-bank offers. Paragraph 43 is an important paragraph which seeks to carve out a special exception for unfair prejudice petitions. And points are made in 4 subparagraphs under that. By way of headline, what I say is that the points that are made in A and B and D are firstly not peculiar to unfair prejudice claims. They could arise in any split trial situation.
Well, as Mr Stone pointed out, that's the way intellectual property cases are usually decided.
Indeed, one can think of many areas of the law where liability or preliminary issues trials are the norm or happen frequently, and as I'll make good in a moment, also, this asymmetry of information on which so much weight is placed is also not at all an unusual circumstance. So the points I make principally about A, B, and D is that this is not peculiar to unfair prejudice, and also it could arise equally where a Part 36 offer is made. So if these are gross injustices, they are gross injustices which are tolerated where Part 36 is concerned because of the greater concern about injustice to the offeror.
I'm not certain if it may be true that in this particular case, or an unfair prejudice case, it is a characteristic. It would be a characteristic in any case where there was inequality of arms as between two parties. But the point I think that is being made underneath paragraph 43 is that the making of a derisory offer would put a relatively impecunious claimant, petitioner, applicant, appellant under almost intolerable stress in litigation terms.
Well, I think your lordships have my submissions on that. I mean, the theme of impecuniosity runs through Milona Friend's submissions, and as I said, as a matter of fact, it's actually no longer relevant in this case. But I come back to saying impecuniosity is not relevant to the incidence of costs. One has to look at both sides of the equation as well. I mean, the way we litigate in this jurisdiction, parties, whichever side they're on, they have to be able to fund themselves.
Well,
impecunious
it's not
defendants.
quite the point that's being made, though. The point is that the costs are being driven up by unreasonable conduct on behalf of your client.
And
it's not simply that the petitioner is impecunious. It's that the costs are being escalated by what she says, and indeed what the judge found, to be your client's unreasonable conduct.
And that will in due course be taken into account. Indeed, the deputy judge did order indemnity basis costs. We make no challenge to that. The court has in its armoury the powers to deal with that. It's a question of when it should deal with that. But we do see in the cases, HSS is one of them, we see others, these arguments about conduct, very serious conduct. HSS was a case where it's been said that the defendant's witnesses have been dishonest, was not enough to displace the reservation. These are all matters which can be dealt with at the end of the case, and appropriate orders made then.
Is there a, I mean, we're increasingly told in these days of austerity and ability to fund expensive litigation, is access to justice a relevant consideration here? That where there is inequality and the respondent to the petition is the company against the minority shareholder, there's at least a probability, putting it no higher than that, that may be inequality of ability to finance a case. You can't see it through to the end. You may have to accept a derisory settlement or pull out or not litigate in the way that you ought to be able to litigate.
Well, my lord, I would say that is just a fact of how we litigate in this jurisdiction. And the relative means of the parties is not, has never been, should not be a relevant factor in the disposition of costs. And I do say that reliance on the respondent's impecuniosity in this case is overblown, not merely because, as I say, the interim payment has now been made, but she has got a legal team acting on conditional fee agreements. She has got, after the event, insurance, and she has apparently had funding to pay for experts' reports. So she has been able to put herself in a position to bring this claim. My client, on the other hand, has had to rely on his own means, which are extremely limited, and to a large extent the generosity of others in order to defend himself. So one does have to look at both sides of the equation. And the fact that actually these can be extremely difficult in investigations is a further reason why they simply shouldn't be relevant in the first place.
But I suppose, take a hypothetical case. Suppose that you've got somebody who has a claim for £1 million, let's say, and there's a split trial of liability and quantum, and there is an offer of, let's say, £250,000. And at the end of the whole process, the claimant only recovers £200,000, so less than the offer. It would still be open to a judge, would it not, to say, well, you, defendant, behaved so unreasonably on the liability issue, your conduct was such as to cause vast amounts of unnecessary costs to be incurred. And although, had you fought liability proportionately, you would be entitled to your costs, the fact is that your conduct was so unreasonable that I'm going to give those costs to the claimant. That would be all right, wouldn't it?
Yes.
Well,
up to the date.
Isn't that, in a sense, what the judge has done here?
Well, my lord, can I just add something to my yes before I come on to answer that question? In respect of, let's assume it's a Part 36 offer. In respect to the period up to the end of the relevant period, the court exercises its discretion in the usual way. Yeah. So that is why I gave an unqualified yes as the answer to my lord's question. After that, then under Part 36, the defendant would have to have the costs unless it was unjust, and the court might inquire into injustice. To come on to my lord's second question about what happened in this case, in my submission, no, that's not what happened, because what the deputy judge did was simply have no regard to the existence of the offer. He decided that he could not, was prohibited under the rules from taking it into account. That's as far as he went. That was all he needed to decide in order to award the petitioner her costs.
Yes. Your case is that he should have taken it into account, but then it flipped one way only.
Yes. That is my submission. He could have considered, if it had been put to him, and my learned friend is perfectly entitled to make the submission now, that it was an exceptional case, but all of the factors, as I'll come on to, which are relied on as making it exceptional, are not actually relevant factors if one takes the approach to exceptionality that was taken in multiplex, which I say is the right approach.
You answer my lord's question by saying, let's assume it's a Part 36 offer, and then you tip into the rules, which, as we've said more than once, are prescriptive, so you have to show in the post-Part 36 period that it's unjust within the meaning of the rules, and there's specific factors to be taken into account. My lord's question was actually in relation to a call-to-bank offer, and is it not the case that in relation to a call-to-bank offer, one could say, I know that you've ended up at the end of the day getting less than the offer, but nevertheless, I still think the defendant should pay for these post-offer costs because of his unreasonable conduct.
Oh, yes.
I think your answer to that is yes.
It is, my lord. The reason why I refer to Part 36 is because even under Part 36, with its codified regime, in the period up to the end of the relevant period, the court exercises its discretion in exactly the same way. Part 36 doesn't govern the exercise of that discretion.
Yes.
But of course, the position is a fortiori where it's a call-to-bank offer. Yes, absolutely, I accept that.
Thank you.
The point I haven't yet dealt with in paragraph 43 of Learner Friend's skeleton argument is C, which is this question of asymmetry of knowledge and information on which a lot of reliance is placed. And I've already made the point, and your lordships will be well aware of it from the breadth of cases, that you see that this is a feature of many forms of litigation, and particularly any case which involves a gains-based remedy. Any case with an account of profits, for example, is going to be a case where the quantum information is inherently on the defendant's side. But it may also be, it's not just those sorts of cases that can be identified as a category. It may just be because the parties are trying liability and have hived off quantum and just aren't investigating it at that time. Now, that may be true, for example, of a large value personal injury claim or a clinical negligence claim. Now, in that situation, the asymmetry of information may be to the claimant's benefit, because it's the claimant that has the information about injuries and losses. So it shouldn't be assumed that asymmetry of information always works one way. But as a feature of litigation, my submission is that it's a relatively common feature. So if you're going to exempt unfair prejudice petitions, which is the submission which is made, on a principled basis, then you're going to have to exempt whole swathes of litigation. And if you can't identify, if you can't predefine what those areas of litigation are going to be, then the very unattractive, in my submission, and really unworkable position that would have to be adopted is that at that point at the end of stage one, there has to be some kind of inquiry into whether the relative states of knowledge of the parties is such that it would be fair or unfair to take any account of the offer. And the difficulties involved in that are, in my submission, very obvious. First of all, it's the court embarking on satellite litigation. But secondly, a lot of the relevant material is going to be privileged. If parties want to tell the court what they do or do not know, they're going to have to show their hand. Now, parties will do that at the end of the case when they're arguing, for example, about what may be unjust. That's a lot easier to do because the whole case has been determined. But can parties really be expected at the liability stage to start showing their hands in relation to quantum to deal with an argument which is so much more easily dealt with at the end of the case? And of course, one can say again, if this is a problem for call-to-bank offers, it's also a problem for Part 36. It's not a relevant point of distinction. And I've already made my submissions about what is the highly unsatisfactory alternative, which really gives the claimant the whip hand during the liability phase and leaves the defendant with no means to protect itself except by conceding liability if it wants to avoid the costs of the liability phase, where it may reasonably have a fighting chance of actually succeeding. It gives the claimant no incentive, really, to engage with the defendant in relation to the stage one proceedings. The defendant might try and make offers, but if the claimant wins, they are necessarily going to beat all of those offers. So what else is the defendant to do?
Well, not necessarily. In an unfair prejudice petition, you generally have a series of things which the respondent is said to have done in breach of their duties as directors and so on. And quite often, some of them are established and some of them aren't. And the fight is, on what assumptions should the value of the shares if they're going to be bought out at the end of the day? So one could have a halfway offer on liability in a case like this, in which the respondent says, well, I'll accept A, B, and C, but I won't accept D, E, and F, and on that basis, I can go off to the valuer. So it's not an all or nothing thing, liability, in a case like this.
In that particular case, no, my lord, of course I accept that. But there will be very many cases where there are liability trials where really it is all or nothing. You may be trying liability because I'm thinking particularly, for example, of high-value personal injury claims, possibly even more general professional negligence claims, where investigating quantum may be enormously expensive. And so you have a trial on liability first to avoid that cost. But the answer may well be all or nothing. And it's in that situation.
You might say, I'll accept liability with a 30% contrib, for instance.
If there were an issue as to contrib, I mean, it may be that a claimant is willing to compromise, but if the claimant isn't, this is the situation I'm positing, where the claimant just says, I'm going to sit here and wait for you to concede liability, because if you try and protect yourself with an offer that relates to the whole of the proceedings, I'm going to argue that no account should be taken of it, then there's really nothing for the defendant to do. My lord, I think that concludes what I need to say about the law.
Yeah.
As far as the judge's decision is concerned, well, clearly your lordships have that. It's quite apparent that at the heart of his decision was a belief that it was not open to him under the rules to take into account an offer which he could not be shown. I mentioned that we had the current...
There are 2 points, aren't they? There is the point that he said, well, this is not admissible, so I'm not required to look at it under CPR 42.4. And then at 33, paragraph 33 on page 56 of the bundle, he says, the admissible offer is one that needs to be taken account of. Judge may look at the offer, etc., etc. He goes on to say, this is not a discretion I can exercise without knowing anything about the offer in question. And I think there must be good reason why the court's discretion is to consider admissible offers. Even if it were open to me to consider the inadmissible offer, I don't know how I would consider it. So that's what he says. I just don't know anything about it.
Yes, my lord, that last sentence is, I say with all respect to the deputy judge, a curious one, because what he was being asked to do was not consider it, it's inadmissible, but he was being asked to reserve the cost precisely because he couldn't consider it. Insofar as his view was that he was not able to take into account the offer under the rules because it wasn't at that stage admissible, then the answer is either, in my submission, that he could take into account the existence of the offer and was being told about it, and that what Lord Justice Waller said in HSS is equally applicable, but also taking the approach from Ted Baker that it was in any event part of all the circumstances. So he had to make his decision. The existence of the offer had to be a factor.
He did cover himself, didn't he, sneakily in paragraph 39. I mean, he said, I'm not going to take it into account, but if I do take it into account, I'll wait until judgment, then I'll sneak in a paragraph, and I'll say, having it on a bit of elementary logic, looking at the maths, I really don't think this would have made an iota of difference. So you've got to say, not only was he wrong to say he couldn't take it into account, but also the inferences, which on the face of paragraph 39 are perhaps not unreasonable, are irrelevant in principle.
Well, my lord, I'm not going to take up your lordship's invitation to call the deputy judge sneaky, but I do have something to say about paragraph 39 specifically. This does not form part of the judgment. It was the subject of a separate ground of appeal, because we do say that what he said there was wrong. And when Lord Justice Nugee granted permission to appeal on the ground that I'm addressing your lordships on, he refused permission on this ground for the specific reason that paragraph 39 does not form part of the judge's judgment. Now, if your lordships take the view that in fact it does, then I would need to renew my application for permission to appeal on that ground. In my submission, it doesn't. It was an embellishment.
Well, I think, well, for my part, it seems to me the judge is right. He'd come to a judgment at that point on the basis he was not able and wouldn't speculate. And he then decided, having made that judgment, that he would engage in a little bit of speculation, a bit of belt and braces.
Yes, and of course it's that speculation which is precisely what, in my submission, one cannot do, because one just does not know. The assumption that this is an offer that wouldn't have made an iota of difference to his discretion is one which he simply could not make.
If that had been in paragraph 36 as opposed to 37, and therefore part of the judgment, you would then have said that was irrelevant, because that is also speculation, even if the facts upon which he was referring are perhaps not improbable. The difference between the two sides was vast, almost infinite, between 0 and 9 million. But you would say he wasn't entitled to do that either, in principle.
He would have been... Now, this comes into a separate aspect of Millennium for submissions, which is, well, even if the principle is accepted, this is an exceptional case. And one of the submissions that Millennium makes under that head is the learned judge could have decided there and then that no matter what the offer, it would not have been relevant to costs. Now, had he said that, and had this, as your lordship says, put that in paragraph 36, I would like to think that Lord Justice Nugee would have given us permission to appeal in relation to that also, because...
your short point would be that speculation and it's therefore an impermissible approach.
It's pure speculation. If the principle is that one cannot know, then one cannot know. And The approach that Malone Friend takes to the concept of exceptionality goes beyond the one instance that we have in the case law of exceptionality being found, which is multiplex, which is a situation where the offer just doesn't engage with the cost that the court is concerned with. The offer relates to this part of the case, and the court is dealing with this part of the case. It is going far beyond what even Mr. Justice Jackson did in multiplex, to say that what the court can do is preemptively make the assessment of injustice at the end of stage one that it would otherwise do at the end of the case. And that you cannot do that under Part 36, we know as a matter of law, because of the original Beauty case, that was effectively what the judge in that case was being asked to do, and he was absolutely clear. The wording of Part 36 prohibits the court from trying to pre-assess injustice, because one of the obligatory considerations is the terms of the offer, and the court cannot know what the terms of the offer are. Now that comes from the wording of Part 36, but I submit it's an elementary proposition outside Part 36. How can you decide that whatever the circumstances, it would not be right to give any effect to this offer, no matter what the level of the offer and no matter what the outcome of the case at stage one? It's an impossible proposition, in my submission. The other aspect of the Deputy Judge's judgment was that he does say, at the end of paragraph 31, that he doesn't accept that the Part 36 principles, he was clearly alive to them, should be read across to other types of offers. But the only reasoning given for that is at the beginning of paragraph 32, where he says effectively, well, you could have made a different kind of offer, and your lordships have my submissions on that.
Well, Part 36 describes itself, does it not, as a self-contained code?
It does, my lord, and the significance of that is always said to be that, for example, considerations of the ordinary law of contract don't apply. So if you want to be within Part 36,
yeah. That's one aspect, but if it's self-contained, that would suggest that it's not generally applicable across the board. It's self-contained.
But these principles don't come from Part 36, my lord. That's the answer to that point. Right. These are common law principles, judge-made principles, based on fairness and policy, which happen to relate to Part 36 offers. And the question is there a principled reason to do anything different in relation to call-to-bank offers? But, my lord, those are the reasons why I submit that the judge's exercise of discretion was flawed and his order has to be set aside, and then I turn to my submissions on what this court should do instead, if the court is with me thus far. Now, the first question is, should this court make any order at all? Because Malone Friend will submit that this should be remitted to the judge to deal with. And in my submission, it should not. If the only appropriate order is that the cost be reserved, then that is plainly an order which this court can and should make. But even if there is a wider discretion to exercise, consideration of exceptional circumstances, whatever it may be, in my submission, here and now, this court is in just as good a position to deal with that as the deputy judge would be, particularly given the passage of time since the order has been made. I then need to deal with the rest of the argument that, well, even if the principle is right, this is an exceptional case, and it's open to this court, and this court should award the costs in any event. And as I've said, in my submission, the starting point has to be, following the HSS and multiplex approach, that the exceptionality has to be an exceptionality which negates the potential injustice. It has to be a submission, in effect, that whatever is relied upon extinguishes any possibility of serious injustice if the costs are not reserved. And that is, except in a multiplex situation where the offer is just not relevant, something which is essentially impossible for the court to determine at that preliminary stage. And many factors are relied upon in Milner Friend's skeleton argument. And aside from impecuniosity, I don't dispute that they will in due course be relevant. Conduct will be relevant. Any offers made by the petitioner herself will be relevant. And indeed, there is an advantage to the petitioner in waiting until the end of the case to deal with these matters, because she will then indisputably be able to put before the judge the material which she wanted to, but never in fact asked the judge to see below. None of those difficulties will arise. The judge at the end of the case can see everything which is admissible then. But none of those matters in my submission, no matter how egregious your lordships view the conduct issues, and as I've said, in the authorities, we see extremely serious allegations of conduct, resulting in a ruling that this can be dealt with at the end of the case. We see that in HSS, we see that in the original Beauty case. And perhaps I'll just give your lordships the references for that in original Beauty. It's paragraphs 13 and 15. All the court is doing is holding the ring, and there remains a risk of serious injustice if an immediate costs order is made. As for impecuniosity, there's one more point to make that I haven't made thus far, but it's an important one. Reliance on impecuniosity simply begs the question. It assumes that the offer was one which the petitioner shouldn't reasonably have accepted. But if the offer ought to have been accepted, then the immediate cause of any difficulty financing stage 2 is the failure to accept the offer. If the offer had been accepted, there wouldn't be any stage 2 to fund. So, yes, another reason in my submission, I want us to be extremely careful acceding to submissions of that kind. I've dealt with the submission that it can be regarded now as inevitably unjust to give effect to the offer. And in a way, I do say that all of Milner Friend's submissions in this regard are really undermined by her argument that there's no injustice to my client if the appeal is dismissed because he could have made a Part 36 offer, because there must be implicit in that an acceptance that if he had made a Part 36 offer, then the cost would simply have been reserved, that this is not an exceptional case under Part 36. And if it's not an exceptional case under Part 36, it has to be explained why it's an exceptional case when one is dealing with a Calderbank offer. And I should, my lord, say something about the scale of the potential injustice that we're concerned with. I haven't said anything about numbers hitherto, but it's important that your lordships know what is at stake here. You will have seen that my client was ordered to pay £450,000 on account of the petitioner's costs. She was claiming those costs at almost £700,000. Now, in paragraph 51 of my skeleton argument, I undertake an analysis of what the petitioner's recoverable costs up to 21 days after the offer might be, what my clients might be by reference to the approved cost budget, and what the net result might be. Now, as far as the petitioner's costs are concerned, we are assisted because last night her solicitors produced a Precedent H style breakdown of her costs up to the 17th of June of 2020. Now, I don't know if there are copies in court that can be handed up to your lordships. I'm very happy for your lordships to see that.
I'm not aware of having seen it.
All one needs to look at here is the total, and in fact it supports the supposition that I engaged in paragraph 51, and in fact makes my figure look, if anything, slightly generous. I accept needlessly complicated the analysis because I overlooked the fact that all of these costs were costs incurred before the cost management order was made. So they are, in terms of the language of the CPR, incurred costs, and they are all subject to detailed assessment in the usual way. So the figure that I used in paragraph 51D as my assessment of what the petitioner's recoverable costs up to the 17th of June 2020 might be, of £127,500. That is probably a bit generous because that figure is actually about 75% of her total costs during that period. That would be a very good result on detailed assessment. So these figures that we now have, these actual figures, they don't falsify, they actually support the figures that I'm using in paragraph 51. My client's own costs are easier to deal with because they are essentially governed by the approved budget, and we have those in the bundle. I don't propose to turn them up. But the upshot of all of this, as we see in paragraph 51E of my skeleton argument, is that it is reasonable for my client to expect that if he ends up getting his costs from the 17th of June 2020 of the liability phase alone, that could be a net liability to him of around and possibly at least £330,000 or so. So the swing on this appeal, if I can call it that, could be approaching £1 million.
What point does this go to? It's good pledge, understand that. Always worth trying to get good pledge in, but what does it go to as a matter of law?
Well, my lord, it's excellent pledge, but it is relevant to the scale of the injustice, because if the court is exercising a discretion, if the discretion is perhaps wider than I'm submitting, if the court is asking itself, do you risk a serious injustice if you don't reserve the costs now, then the numbers are in my submission relevant. If it could be shown, well, it might be relevant, it's not this case, so I don't need to nail my colours to the mast, but there might be a case in which the numbers were so close together that the court could say, well, I see what the result might be, but these factors are so significant that I can regard them as overriding what might be at stake. So the only reason I show these to your lordships is to show your lordships that there is a very significant amount at stake, and to go on to say that if there is any appreciable chance that my client could be unjustly denied the opportunity to achieve that different result, then the cost should be reserved.
Yeah.
And the final point that I need to deal with is, in fact, where my Lord Justice Lewison in many ways started, is the question of, well, should the court make an order dealing with the costs up to 21 days after the offer and reserve the costs thereafter? Well, my broad submission is that that would be inappropriate. If the court is going to reserve some of the costs, then it should reserve all of the costs. We don't see that happening. We don't see even attempts at that happening where Part 36 is concerned. And we see in the authorities that the question has been asked twice and it's been rejected twice. In fact, no, I'm sorry, my lord, I misled you. One of the case I'm going to go to in a moment, lifestyle equities, it was a Part 36 case. So the question was asked in that case, but it was rejected. So we've got Tullet Prebon, where it was asked and rejected in relation to a call-to-bank offer, and we've got lifestyle equities, where it was asked and rejected in relation to Part 36. We don't actually have an example of a split order of that kind being made. And if I can show you the trenchant dismissal of that as a proposition by His Honour Judge Pelling QC in Lifestyle Equities, that's tab 16 of the authorities bundle, page 165, paragraph 28. And he said there, it seems to me that to embark upon a methodology which involves imposing an order for costs for part of the trial of liability, then addressing the issues of costs that arise after the date of the Part 36 offer, so far as liability is concerned, and then also to attempt to deal with costs in relation to any quantum inquiries, is a recipe for complexity, prolixity, and avoidable expense, both in terms of costs for the parties and resources so far as the court is concerned. Where there has been a Part 36 offer made and the parties have either been ordered to or agreed to split the trial between liability and quantum, the appropriate course is to wait until after the quantum issues have been resolved before attempting to address questions of costs. And in my submission, that is the right approach. But there is also, and one of the reasons why my submission that is the right approach, is that there is no need at this stage unduly to fetter the discretion which the judge at the end of the case will exercise. Now, if one looks at this case, for example, one may say right now there is good reason to think that the petitioner will get her costs up to the 17th of June 2020 in any event. But your lordship will be aware that one of the arguments that was made on behalf of my client below was that he had made an open offer of to purchase the petitioner's shares for £25,000, and that was an offer that she should have accepted because they are in fact worth less than that. Now, as a reason to reserve the cost generally, that was rejected by the deputy judge, and Lord Justice Nugee refused permission to appeal. But I do say that it's open to me to submit that when it comes to the end of the case and all questions of costs are being looked at, if in fact the result is that the shares are worth less than £25,000, then that will be a relevant consideration in relation to the liability costs even before the date of the offer. We cannot rule out at this stage that that is a possibility and that it's a factor that the court would want to take into account. And the final point, my lords, to make about this is that one has to ask, what is the point of making an offer now? Because, an order now. It does the petitioner no good by itself unless it's going to be accompanied by a payment.
Can I just backtrack for 30 seconds? You're inviting us to, if you like, speculate what might be the end result. You're criticising the judge for doing that, he being in far better possession of the facts and having a view as to what the likely share valuation might be at the end of the day. And he was not accepting of your view that it was likely to be 25,000. Now, that was his view, as recorded in the judgment, but you're inviting us to speculate that it might not be true, something else. I mean, if he can't speculate, we can't speculate.
I put it slightly differently, my lord, to the way it was put before the deputy judge. Before the deputy judge, the argument was there is a good enough chance that the result will be less than £25,000, that for that reason alone, you should reserve the whole of the costs. That was the submission. And I can't make that submission anymore. And his view was that that was sufficiently unlikely not to be a reason to reserve the costs entirely. But it is different to say he didn't rule it out as a possibility at all. It just wasn't a sufficiently likely policy to justify not making a cost order there and then. But it cannot be ruled out as a possibility in the end. And if that possibility eventuates, that is likely to be relevant. And that is not to invite speculation. It's to not to read more into the deputy judge's decision than in fact he decided.
He said it was highly unlikely that her ultimate recovery would be less than 25,000, and he described that possibility, I think, as a small chance, a small prospect.
Yes.
So that was an educated piece of speculation. I mean, it was his intelligent analysis on the basis of having sat through a 9-day trial.
Yes, and he was clearly entitled to form that view because we were refused permission to appeal that aspect of his decision. But the question is, should the court fetter the discretion of the ultimate decision maker when it doesn't need to do so? Or to put it another way, what is the countervailing benefit of fettering the discretion? Does it justify doing so? And what I was just about to come on to is, well, there is only benefit to the petitioner if it means she gets the money, if a payment on account of those costs is made. And in my submission, it would be wrong in principle, even if she was given those costs, to order a payment on account of them, because that would deny my client the possibility in due course, if in fact his position on the offer is correct, the opportunity of having those costs set off against a much larger liability to him. And that is a concern. I'll just give your lordship the references, but that is a concern which features in two of the cases. In the Biber case, which is page 131 of the authorities bundle at paragraph 31, and also in Tullet Prebon, page 95 of the bundle at paragraphs 7 to 8. And that is particularly so when the current state of play is that petitioner cannot say that she needs funds in order to carry on with the proceedings. She should now be in a very good position to do so. Would your lordship give me a minute?
Yes, of course.
No. My lords, those are my submissions.
Thank you, Mr. Carpenter. Yes, Ms. Lindner.
Thank you, my lord. The respondent's position is, on this appeal, in summary, that firstly, the judge was correct not to treat the appellant's called bank offer as equivalent to a Part 36 offer, and that he exercised his discretion in relation to costs correctly. And secondly, that even if the judge erred in his treatment of the appellant's called bank offer, the order he made was still within his discretion properly exercised, and it was the correct order in the circumstances of the case. This second point is important because the appellant is asking this court to substitute the order that was made with its own order that costs be reserved. And in doing so, the appellant is effectively asking this court to undertake a fresh exercise of the court's discretion as to costs. The petitioner's position is that if the court is going to undertake that exercise, then it is entitled to, indeed it must, consider all of the relevant circumstances of the case. I'd like, if I may, to take my submissions in the following order. Firstly, to address your lordships in general terms in relation to the approach to be taken by the court in exercising its discretion to award costs in a split trial. Secondly, to address your lordships on the difference between Part 36 and call-to-bank offers, and why we say the judge was right not to treat the call-to-bank offer as equivalent to a Part 36 offer. Thirdly, to address your lordships on the specific circumstances of this case, and explain why those circumstances justified the making of an immediate cost order in the proper exercise of the court's discretion in any event. This is relevant both to the exercise of the court's discretion that I say that it properly has, but also to the question of whether there are or were exceptional circumstances, and in the event that your lordships are with my learned friend on that point. And then finally, I'll address your lordships on what it means for this appeal if the appellant is correct in his assertion that the judge should have treated the call-to-bank offer as a Part 36 offer for the purposes of determining costs. So, dealing first with the approach the court should take to costs in a split trial, and this is dealt with, my lords, at paragraphs 24 to 30 of my skeleton. The authorities make clear that the court should seek to avoid a winner-takes-all, kitchen-sink approach to costs during the course of the litigation. The classic statement of this is found in the words of Lord Wolfe in Phonographic Performance and AEI Red Fusion Music Limited. I don't think I need to take your lordships to the report, but the relevant statement, which is at paragraph 26 of my skeleton, is that it is now clear that too robust an application of the follow-the-event principle encourages litigants to increase the cost of litigation, since it discourages litigants from being selective as to the points they take. If you recover all of your costs as long as you win, you're encouraged to leave no stone unturned in your efforts to do so. And a similar point was made by my Lord Justice Nugee before your lordship was elevated to this court in Merck and Merck Sharp and Dome Corporation, which is referred to at paragraph 28 of my skeleton, when your lordship said it is in general a salutary principle that those who lose discrete aspects of complex litigation should pay for the discrete applications or hearings which they lose, and should do so when they lose them, rather than leaving costs to be swept up at trial. So, for example, the court is expected to consider making immediate cost orders in interlocutory applications and preliminary issues, notwithstanding the fact that the paying party may go on to win the action as a whole. My learned friend seeks to distinguish that type of hearing on the basis that they are contained freestanding aspects of the litigation. I say precisely the same thing can be said for about the issues that were to be determined in the November trial. Judge Thompsell picked up both of those references in his judgment at paragraph 12 and observed that the general rule about costs should be general rule is that costs should be awarded following the first stage of a split trial reflects the modern emphasis of the CPR rules on using costs to encourage parties not to take unmeritorious points by being ready to award costs according to who has won at different stages in the action, rather than taking a winner-take-all approach at the end of the action. In my submission, the contention that the court should avoid awarding costs on a winner-takes-all or kitchen sink basis should apply with equal force whether the party is a winner at the end of the day because they've succeeded on their case, or whether a party is a winner at the end of the day because they've made an offer to settle that the defendant has failed to beat. And we see evidence of that in the way that courts are able to make cost orders in relation to interlocutory applications and preliminary issues without having regard to the existence of, for example, a global Part 36 offer to settle. And I should say that I appreciate that there are specific rules that relate to Part 36 offers and that particular considerations might apply to that prescriptive regime, which is a whole ecosystem of its own, but I will come on to that. So there are, in my submission, very good policy reasons why the court should avoid a winner-takes-all approach in relation to interlocutory or split trial costs, where there have been global offers made. If parties are to be encouraged to conduct litigation efficiently and at proportionate cost, then they should be encouraged to compromise specific issues within litigation, thereby narrowing the issues the court is asked to decide and limiting the cost that each side is forced to incur.
So your point is that as a matter of general policy, the court's discretion over costs is not to be exercised on a winner-takes-all basis. The loser should pay the costs as the case progresses on discrete elements of the case. There may be a specific carve-out from that in the case of Part 36, but unless you are within the walls of Part 36, the general policy prevails.
Quite. Thank you, my lord. And the two factors that my learned friend sets out at paragraph 3 of his skeleton as being factors that the court must take into account when exercising its discretion to make an immediate award of costs are, firstly, that the ultimate incidence of costs should not depend on the happenstance of the case management decision that the trial be split, and secondly, that an immediate costs order shouldn't be made if subsequent events might render that order unjust. So dealing with those in turn, whilst I accept that the point about the happenstance of case management decisions might be relevant in some cases, in my submission, it is not a relevant consideration in the context of unfair prejudice petitions. And I say that because in unfair prejudice petitions, it is very much standard practice for the issues at trial to be whether there has been unfairly prejudicial conduct, and if so, what remedy should be ordered, and for there then to be a second follow-on part of the litigation to determine the value of the petitioner shares if, for example, the remedy ordered is a share buyout. And indeed, if one looks at the relief that was sought in Mrs. Langer's petition, the remedy that she was seeking was simply an order that Mr McKeown purchase her shares at a price to be determined. That is the order that she obtained. That being the case, the fact of there being a split trial is not brought about by chance or the happenstance of a case management decision, and there is therefore nothing arbitrary about a cost order being made after the first stage of the proceedings. Parties to an unfair prejudice petition where a buyout order is sought generally expect there to be a split trial, and they're able to take steps to protect themselves and costs on that basis.
You would have to say the same about intellectual property trials, wouldn't you?
You may well do. I don't know very much about intellectual property proceedings, but
well, almost always infringement is decided,
yes.
And then the claimant has the choice usually to elect between damages or an account of profits, and there is a certain amount of disclosure which takes place to enable that election to take place, and then assuming infringement to be proved, the case then moves on to either award damages or conduct the account.
My Lord, nothing in my submissions today turns on me establishing that unfair prejudice petitions are unique. I simply make the case that there are certain characteristics of this type of proceeding, which may also arise in certain other types of proceedings, that require a particular approach to costs.
But your point is simply that it's not happenstance. It's
Right.
in the nature of the dispute time
Exactly.
that there tends to be a split between liability and remedy, which could occur in other areas as well.
Dealing with my learned friend's second proposition, that an immediate cost order should not be made as subsequent events might render that order unjust. It's worth noting at this juncture that the only authorities that were relied on by the appellant's counsel at the hearing below in relation to the question of whether costs should be reserved were HSS, Hire Services, and Interactive Technology and First. In particular, there were no authorities put before the judge in which a court had reserved costs in a split trial by reason of the existence of a called bank offer. And so we're, to a very substantial degree, arguing this point for the first time before your lordships today, and no criticism should be made of Judge Thompsell for failing to refer to authorities such as Weil and Mean Fiddler or Dingus, because they simply weren't put before him. I accept, in principle, that where the court is satisfied that there is a real risk its decision on costs will change because of something that might happen later in the litigation, that might be a matter in the circumstances of the case which justifies the issue of costs being reserved. However, the court still has to act in accordance with the requirements of Part 44.2 and Part 36, and it also has to balance the possibility of future events occurring with the principle set out in Phonographic and in Merck that the court should not just reserve all of the costs of proceedings until the end on the basis that whoever wins the action as a whole should receive all of their costs. And I also say that the court has to balance the possible injustice to the successful party of reserving costs. So it's not just about whether there might be injustice to the paying party, it's also relevant to consider whether there might be injustice to the receiving party. And I say that that consideration is particularly relevant in this case. There is in my submission a distinction to be drawn between cases in which the court is mandated by the rules to take a particular approach and cases where the court is just exercising its discretion under Part 44.2 as currently. My learned friend is wrong, I say, to submit that the court's approach in Part 36 offers does not come from the rules and that it's simply an application of common law principles. I say to the contrary, it does come from the rules. If I can begin with HSS, which is behind tab 8 in the authorities bundle at page 76. Now, this was a case which dealt with whether a payment into court required the costs of a split trial to be reserved. And if I can ask you to look, my lord, at paragraph 32, you'll see that the rule that the court was applying was the old Rule 44.3, which provided that in deciding what order, if any, to make about costs, the court must have regard to all the circumstances, including, and what's relevant is C, any payment into court or admissible offer to settle, etc. Now, that wording does not appear in the current Rule 44.2. All the court's required to have regard to is admissible offers other than Part 36 offers. If I can ask you now, my lords, to look at paragraph 35, the court concluded that since it had to have regard to any payment into court, but Rule 36.19 provided that it couldn't have sight of any payment into court until the end of the proceedings, it could not comply with the requirements of Part 44.34c as then in force until it knew about the amount of the offer. So it wasn't simply a question of asking whether anything might change. The court was saying it could not exercise its discretion in accordance with the rules until it knew about the amount of the payment in. Similarly, in Original Beauty and G4K Fashion, which my lord appears behind tab 19,
That's the point you're just making, really flow from the word must in 44.3, because it's mandatory. And one of the matters which must be considered is a payment in. If you can't do that and you can't apply 44.3, therefore the only thing you can do in order then to comply with 44.3 is defer.
Quite. So although there isn't a specific rule that says in these circumstances you must defer, the rules do mandate the cost being reserved because the court can't comply with the terms of its discretion, with the scope of its discretion.
Well, that's the point Lord Justice Waller makes in the last sentence of paragraph 36, I think. Because the court was not allowed to know the quantum, it could not act as required under 44.3.
Right. Yes, exactly. It's not a question of common law discretion, my lord, or a common law principle. The approach in HSS services is derived directly from what the court was being mandated to do by the rules. Similarly, in relation to Part 36, because the court is required to give effect to the prescribed consequences of a Part 36 offer having been made and rejected, it's required to do that. The court can't comply with its obligations under Part 36 until it knows what effect the offer has. And it can't know what effect the Part 36 offer has until it sees the Part 36 offer. So in my submission, that is the principle running through the cases in relation to Part 36. It's not a common law principle, it's derived from the rules themselves. And if I can just take you to one example of that in relation to Part 36, if I can ask you, my lords, to turn to tab 19.
This is Original Beauty.
Original Beauty, right.
Yeah.
And paragraph 14, which is at pages 198 to 199. What the court said at the top of paragraph 14 is it does seem to me that the language of CPR 36.17 is very clear on its terms and prevents the court from making a cost order on the agreed facts of this case for the following reasons. And then it explains that the effect of 36.17 is that it's not allowed to look at the Part 36 offer until it's been made, until the end of the case, sorry. And then over the page, whilst the court has been informed of the existence of the Part 36 offer, it is expressly prevented from being told its terms, when it was made, what the parties knew at the time, and how the parties exchanged information for the purposes of evaluating the offer. Without that information, the court cannot take it into account and so cannot comply with CPR 36.17.5. That's why the court considered it had to reserve costs.
Just pausing there for a moment.
Yes.
What is it that stops the court being told when the offer was made? Mr. Carpenter, I think, accepted that the court could be told, A, that an offer had been made, and B, when it was made. But the deputy judge here says it's expressly prevented from being told when it was made.
I don't think that the court is prevented from being told when the offer is made. In my submission, that's an error. There is, not to my knowledge, a provision within Part 36 that requires that. Yes, and in fact, when one looks at the factors, the list of what the court is not allowed to know on at the bottom of page 198, the non-exhaustive.
No, that's not what it's not allowed to
No,
know.
sorry, I'm sorry. You're quite right, my lord.
That's whether it's unjust. But there is a provision saying if you've got a split trial, you are not allowed to know the terms of it, but you are allowed to know that not a Part 36
Yes.
offer has been made.
16, I think.
Yes. And in fact, we have.
It's 3616.
Yes.
The trial, in a case to which paragraph 3D1 applies, that is split trial, the trial judge may be told whether or not there are Part 36 offers, plural, but must not be told the terms of any such offers.
Yes.
So it's the fact of the offer is out there, the terms of the offer are not.
Right. And whether
But it doesn't say anything about the date of the offer.
it doesn't, no. In my submission, that's the date of the offer is not one of its terms. So, my lord, where you have.
You say the date of the offer is not part of its terms. So you can tell, in a Part 36 case, which this is not, but you can tell the judge at the end of stage 1, on the 27th of May, a Part 36 offer was made.
That's certainly my understanding. However, it's not. It's not something that I'm making a firm submission on because I simply haven't.
Well, I mean, take an example. There's a 2-week trial, and it ends on the 1st of May in a particular year, let us suppose. And the defendant made a Part 36 offer on the 29th of April, while the trial was going on. It would be very strange if the court was simply to, oh, we made a Part 36 offer.
Yes.
That's it, that's all you can know.
I agree. Yes. I don't understand there to be any real dispute between me and my learned friend on this point.
Distinction in 36:16(4) seems to be whether the offer has been made and its terms. And if one asks which of those two camps is the date more likely to fit into it's whether or not the offer was made. An offer was made on such and such a date. Can't tell you what the terms are. Unless you say the date in the agreement is part of its terms.
And the date on, because the date on which Part 36 offers are made is obviously very important when one's considering the effect of such an offer. I would be surprised if that wasn't the case. So yes, it is my submission that the court is entitled to know the date on which the Part 36 offer is made.
Does a Part 36 offer have to say you've got 21 days to accept it, or can it give a longer period for acceptance?
I believe it's at least 21 days, but I'll happily be
Yeah,
corrected.
35(1)(c), a period not less than 21 days.
So, my lord, where you have a mandatory rule requiring the court to have regard to a particular matter in determining costs, in my submission, that acts as a qualifier on the general discretion. And it's not so much a question of asking, might anything happen that might change the court's mind about costs? It's a question of asking, do the rules permit me to make a cost order at this stage? There is no mandatory rule in relation to call-to-bank offers, which is why I say you can't read across the authorities on Part 36 to call-to-bank offers. Where, however, there is no specific rule, such as in the case of call-to-bank offers, mandating judges to take into account something that they cannot know until the end of the trial, I say the position is much more nuanced. An example of this is where a claimant succeeded on liability, but there is a prospect of them going on to recover nothing during the liability stage. And that was the point that was dealt with in Weil. And if we could just turn up Weil, which is behind tab 7 of the authorities bundle, and in particular, turn to page 66.
I'm sorry, I missed the page. 60?
66, the final page.
66, yes.
The judge in Weil below found that the possibility that the claimant would recover nil or nominal damages at trial and justified an order that costs be reserved. And in upholding the judge's decision, the Court of Appeal did not find that the possibility that the claimant would not recover anything at the valuation stage required the judge to reserve costs, the cost of the liability stage. What it found, with some hesitation, was that it is not possible to say that the judge's decision was clearly one which he was not entitled to reach. And then at paragraph 33, the fact that only nominal damages are awarded after a single trial of the issues of liability and damages in the circumstances of a particular case may constitute grounds for refusing the claimant his cost or his full cost of the issue of liability. And there is much to be said, and it goes on. Down to, if this is so, in the case where there is a split trial and it is left uncertain until conclusion of the trial on quantum whether the claimant will recover more than nominal damages, it may be proper for the judge to defer making any order for costs of the trial of the issue of liability until the final outcome of the action is known. This may be the case whenever the judge considers there is a real possibility that the outcome of the assessment of damages may affect the merits of the party's entitlement to the cost of the issue of liability. If the judge forms the view that it does, he must consider carefully whether justice to the defendant requires him to postpone any decision on costs until the final outcome of the action is known.
Well, the next sentence is probably your best sentence, isn't it? It's a recognition that it's an exercise of discretion.
Yes, quite.
I do not think the judge's decision in the exercise of discretion. So it's not, he could have gone the other way. He didn't, but he could have gone the other way is the implication.
Well, the very fact he has to consider it carefully suggests that he's got to weigh up the two considerations. On the one hand, there's an interest in people who lose bits of litigation, paying for them there and then. On the other hand, if there's a real possibility that at the end of the day the claimant's going to recover nothing, that may be a relevant consideration.
If I can move on then to the second part of my submission, which is the effect of Part 36 offers and call-to-bank offers on the issue of costs and the difference between the two. This is plainly the fundamental difference between the parties on this appeal, and I say that there are at least two principled and important ways in which Part 36 and call-to-bank offers are different, and why the judge was correct to find that he was not required to treat Mr McKeown's offer as equivalent to a Part 36 offer. And whether one calls it a hierarchy or not, I say the point is that the two types of offer are subject to different rules. And I should make clear at this juncture that I'm dealing in my submissions only with the principles, so nothing in my written or my oral submissions as the potential quantum of a call-to-bank offer in theory should be construed as implying anything about the terms of the call-to-bank offer that's made. So the first principled reason why the two types of offer should be treated differently is very simply that the two types of offer are subject to different rules. Part 36 is a formal, self-contained regime that has prescriptive rules about the way in which offers should be made and the consequences of those offers being made, accepted or rejected. So parties making or being made a Part 36 offer have a reasonable degree of certainty as to what the consequences of that offer will be. And in particular, pursuant to Part 36.17, there are specific mandatory cost consequences that flow in the event a claimant fails to beat a defendant's Part 36 offer or payment into court, and to which the court is required to give effect unless it would be unjust to do so. And this comes back to the point I was making before. That being the case, as I said, it's unsurprising that the authorities on undisclosed Part 36 offers in split trials suggest that in all but exceptional circumstances, so still reserving a discretion for the court, albeit a limited one, the court should reserve costs.
And the way that Part 36, if I understand this correctly, feeds into Part 44 is through 44.9, which says 44.9.1 talks about deemed offers, so deemed orders. So under 44, there is a deemed costs order when 36.1, so 36.13 or 38 or 30, yeah.
I think this deals with a slightly different point, which I'm going to come on to,
Okay.
which is that if a claimant, if a defendant, makes a Part 36 offer, he accepts liability to pay the claimant's costs in the event it's accepted. And
Yes, I
in
see.
that case, if there is deemed to have been made a cost order in
Yeah,
I think that's what that means.
I see. Yeah.
So under 3617.4, which is the mandatory costs order, it's not technically a deemed order, but it tells the court what it must do unless it's unjust.
Interestingly, though, while your lordships have Part 36 open, if I can ask your lordships to look at the commentary at Part 36.16.
Commentary at?
36.16.1. On split trials. Because what the authorities on Part 36 don't deal with is the situation where there are global Part 36 offers to settle and offers to settle that deal only with the issues that have been decided at a particular hearing or stage of proceedings. And the what's said in the commentary of the White Book is that in the third paragraph down, it's anticipated that these new rules will encourage parties to make Part 36 offers in split trial cases that relate only to the preliminary issues, perhaps coupled with global Part 36 offers. It remains to be seen how judges will approach the issue of costs when they're told about the terms of an effective Part 36 offer relating only to the preliminary issues, but also that the other parties made a Part 36 offer that remains subject to the restriction under Rule 36.16. On one view, courts may continue to reserve costs of the preliminary issue trial on the basis that costs can only be decided when all Part 36 offers are known. On the other hand, it's anticipated that judges may take the view that parties should focus upon the preliminary issues and make discrete Part 36 offers in respect of those issues. If so, judges may be more inclined to make immediate cost orders at the end of a split trial, armed now with the relevant information in respect of Part 36 offers relating to those issues. Such an approach would be consistent with that taken on interim applications where the possible existence of a global Part 36 offer does little to protect a party who loses an application or declines a well-pitched offer made without prejudice save as to cost to settle the application. Further, it would perhaps be more consistent with the scheme of the Wolf reforms to make an immediate cost order and require payment or at least some sum on account of cost liability as the case progresses. So that is an approach that I would endorse, but it's clear that even within the rigid Part 36 regime, there is scope for the court to make immediate cost orders in split trials where there are admissible and inadmissible Part 36 offers to settle. By contrast, with the prescribed Part 36 offer, called bank offers do not follow a rigid regime. There are no specific requirements on a party who makes such an offer. And, importantly, there are no automatic cost consequences of making a called bank offer, to which the judge is required to give effect. The court is therefore not constrained in its discretion to award costs by a need to comply with the strictures of Part 36, and for that reason I say that the authorities to which my learned friend refers in relation to Part 36 cannot be read across to called bank offers. When a called bank offer has been made, the court's jurisdiction to make a cost order on a split trial is simply the general jurisdiction found in CPR Part 44.24. The requirement pursuant to Part 44.24, which is in the authorities bundle, if that's easy for your lordships, behind the first tab. The general discretion to costs requires the court in deciding what order, if any, to make about costs. The court will have regard to all the circumstances, including the conduct of the parties, which I say is relevant in this case, whether a party has succeeded on part of its case, and any admissible offer to settle made by a party which is drawn to the court's attention and which is not an offer to which cost consequences under Part 36 apply. Now, the judge interpreted this as meaning that the inclusion of the word admissible operates to exclude consideration of inadmissible offers. That's at paragraphs 31 and 33 of his judgment. I say that was a legitimate interpretation and an approach that the judge was entitled to take. The drafters of this rule could have required the court to have regard to any offer to settle other than a Part 36 offer. They could have required the court to have regard to the existence, but not the terms, of any inadmissible offer. By specifying the type of non-Part 36 offer that the court was required to have regard to, i.e. admissible offers, the Rules Committee have given a very strong indication that the court should not take into account the existence of non-admissible offers.
Does that follow? Does it follow that because the court is required to take into account admissible offers, it can't take into account inadmissible ones? I mean, there may be a question of how it can take into account an inadmissible offer of which it knows nothing.
Yes. It may be that in the circumstances of the case, the judge considers the existence of an inadmissible offer, the terms of which it doesn't know, to be something that he or she considers it would be just to take into account. But they're not required to do that.
No.
My learned friend relies on two authorities in which the court has read across the authorities on Part 36.
Well, Ms Littler, if we're going on to authorities, would this be a convenient moment to have a break?
Certainly.
2 o'clock.
Thank you.